Mr. Kobach, I think it is only fair to inform you that last night the committee received a letter from the Southern Poverty Law Center, as you know, one of the nation's preeminent civil rights organizations. Without objection, I ask that the letter be made a part of the record. They have expressed concern that you are testifying in your capacity as a law professor rather than your role as legal counsel for the legal arm of the Federation for American Immigration Reform, and advise us that this is a job for which you have received at least $125,000 in payment. They also draw the committee's attention to a donation from FAIR to your congressional campaign when you ran and condemn FAIR for its ties to the white nationalist movement, and they have asked us not to take your testimony. We take their concerns seriously, and certainly we do respect the work that the SPLC has done against racial violence and police brutality as an inspiration, really, throughout the years. Ultimately, however, and I want to note this because it was an official request, we respect the right of the minority to call their own witnesses. And so it is our opinion that the best response to this request is not to disinvite you, but to hear what you have to say. And I just wanted to make clear that that was the determination that I have made as chair, that you have a right to be heard. And we will begin first with Professor Harris.
Madam Chair, just a colloquy inquiry, if you might.
Certainly.
I'm a little off pace here, but I think I know what I heard, and I'd inquire as if that same approach would be used by the chair if it happened to be a witness that had any association with MALDEF or La Raza or any organization that might be viewed by people on the other side of the political aisle to be racist organizations.
The gentleman is asking for an answer to a speculation which I am not prepared to ask. I would suggest that we go to the witnesses, and I recognize Professor Harris for his 5 minutes of testimony.
Thank you
so much. And we will go now to questions from the committee, and I'd like to offer an opportunity to the ranking member to begin.
Thank you, Madam Chair. I would temporarily defer that to my deputy ranking member, Mr. Harper.
All right.
Thank you.
Mr. Harper is recognized for 5 minutes.
Professor Kobach, before we get going on some questions, I know there were certain allegations made against you in the before you had an opportunity to give your intro. Would you care to address those for a moment?
Yes, I would. Thank you. I'm not receiving any money for this testimony. This is in my personal capacity, although my primary qualification is as a professor of constitutional law and immigration law and as a former Department of Justice employee. When the slanderous letter from the SPLC was read into the record, mentioning these slanders instead of the rest of my CV, what was left out was that, by what was put in the record is the fact that my law degree was from Yale, my doctorate is from Oxford, and the cases that have been brought that I have litigated on behalf of U.S. citizens have been victorious in federal courts across the country, including in the California Court of Appeals. And I guess the point is that when false accusations from a spurious organization are read into the record of an institution as hallowed as this one, I think it does a disservice to the institution. And I'm not saying that the chairwoman had made a decision of her own to do this, but I just think that it's horrible because there is no. It hurts me to be associated with any beliefs that are racist in nature. It hurts my family to see me associated with such beliefs, and I think that such activities of organizations like that are reprehensible and should be prosecuted to the full extent of the law if there are such race-based activities occurring, but I would never associate with them, and I just think it is horrible that a smear like that can be read into the congressional record.
Professor Kobach, I'd also like to ask you another question. I know you've been very successful on litigation across the country dealing with these particular types of issues. As we obviously we detest the concept of racial profiling, but how do you balance the issues of trying to provide for border security, items of national security that we have? Is this something, if we take, obviously you're saying that that ICE is not proper, there's not enough agents. that can handle this problem on their own. Am I correct in that?
I think that's a fair statement. We always need more ICE officers.
Right. So 287, in order to deal with this issue of concern of some reported incidents of racial profiling, doing away with 287G, would that be the solution to that?
Not at all. And I'm glad you asked that question, because one of the witnesses on the previous panel mentioned some jurisdictions that there were reports of incidents, not formal findings, but just reports of racial profiling, and the jurisdictions weren't even Section 287G jurisdiction. So to assume causality, to assume that a 287G agreement somehow causes or facilitates racial profiling is simply illogical. And I would note furthermore that the officers who have received 287G training have received twice as much training against racial profiling as any other officer in federal state law enforcement. They received their own state-level training against racial profiling, which every state gives, and they've received ICE training against racial profiling. Most federal officers have only received one set of classes, so they are actually very well trained. And I would finally note that throughout the entire testimony of every other witness that we have heard today, there have been reports, anecdotes, but there has not been one internal affairs investigation that has ever found any racial profiling by a 287G officer. There's not been one court that has ever found any truth in any report of any racial profiling incident. We are a country of the rule of law, and we do not punish people based on mere allegation or mere anonymous report. We are a country where we have inquiries done under rules of law, and under such inquiries there has never been any finding of any racial profiling associated with 287G.
The men and women of this office are sick and tired, absolutely sick and tired of picking up a paper, watching the news, and being accused of racial profiling. We do not racial profile. We've never racial profiled. We never will racial profile. And accusing us of racial profile amounts to calling us racists. We are not racists. We go out here every day, put our lives on the line, and enforce the law. That's our job, enforce the law. And I also got a message from the men and women standing behind me, for the mayor of Phoenix, Phil Gordon. It's a very simple message. I think he'll even comprehend this. Shut up. You need to shut up. You know nothing about the men and women of this office that go out every day, put their lives on the line in the field and in the facilities. You need to shut up. You need to focus all your attention and all your energy on being the mayor and not being the poster boy for a bunch of activist groups. I am sick of it. They're sick of it.